January 21st, 2026 will be remembered as the day American democracy faced its most dangerous test in modern history. A sitting president of the United States is about to watch his financial empire torn apart by the very legal system he once commanded. This is Warfield Chronicles, and what I'm about to share with you isn't speculation or political theatre. This is documented reality unfolding in real time, and the next 72 hours will determine whether our constitutional framework can survive the collision between executive power and the rule of law. Stay with me because every single detail matters, and by the end of this investigation, you'll understand why scholars are already comparing this moment to Watergate, but with stakes infinitely higher. Wednesday morning, 8:47 Eastern Standard Time. Inside a courtroom in Lower Manhattan, Judge Arthur Engoron signed a document that legal historians will study for generations. The order authorizes immediate execution of judgment against the Trump Organization. Not a warning, not another delay. Actual seizure proceedings. The kind where sheriff's deputies show up with court orders, change locks, and take physical control of assets worth hundreds of millions of dollars. We're talking about Trump Tower on Fifth Avenue. We're talking about 40 Wall Street in the financial district. We're talking about the Seven Springs estate spanning 213 acres in Westchester County. All of these properties, all of these symbols of wealth and power accumulated over 5 decades, now face active confiscation by the state of New York. The question isn't whether this is legal. The question is whether America can function when its president is simultaneously fighting to prevent his business empire from being liquidated by a hostile state government. Let me walk you through exactly how we arrived at this constitutional crossroads, because the chain of events reads like a legal thriller, except every word is verified fact. February 2024. Judge Engoron delivers his verdict in the civil fraud case brought by New York Attorney General Letitia James. The Trump Organization systematically inflated property values to deceive banks and insurance companies. The fraud wasn't minor. It wasn't a technicality. Financial institutions were misled about asset values by hundreds of millions of dollars. The penalty reflects the severity. $464 million in disgorgement of ill-gotten profits, plus interest accumulating daily. Under New York civil procedure law, appealing a money judgment requires posting a bond worth 120% of the total. That meant securing approximately $557 million in guaranteed funds before any appeal could proceed. Without that bond, the judgment becomes immediately enforceable. The state can start seizing assets within days. Finding an insurance company willing to back a $557 million bond for Donald Trump proved nearly impossible. His assets were the subject of the fraud case itself. His liquidity was questionable. His credit rating was toxic. Major underwriters refused to even review the application. Chubb said no. Berkshire Hathaway said no. AIG said no. Lloyd's of London said no. The consensus across the insurance industry was unanimous. Trump represented uninsurable risk. Finally, a second-tier bonding agency based in California called Knight Specialty Insurance stepped forward. They weren't doing this out of goodwill. They demanded collateral. Trump put up liens on multiple properties, including commercial floors of Trump Tower and the entire Seven Springs estate. The bond was issued in March 2024, and for 22 months it held. But Knight Specialty was playing a dangerous game with their own solvency. Here's where the financial engineering becomes critical to understanding today's crisis. Knight Specialty Insurance wasn't some small regional player. They were heavily leveraged into commercial real estate debt instruments across the United States. When the commercial office market started its catastrophic collapse in late 2025, Knight's balance sheet began hemorrhaging red ink. Office buildings in every major American city were defaulting on loans. Remote work had permanently gutted demand for downtown office space. Property values dropped 40% from peak valuations. Suddenly, Knight's reinsurance partners, the larger companies backing their bonds in case of default, got extremely nervous. They started pulling coverage. They started demanding Knight reduce exposure. Then came Monday, January 19th, 2026. Moody's credit rating agency downgraded Knight's specialty insurance to junk status. Their ability to write new bonds was immediately suspended. More critically, according to internal memos leaked to the Wall Street Journal, their existing bonds became subject to emergency recall if risk profiles exceeded newly established thresholds. Tuesday morning, Knight's Risk Management Committee held an emergency session. They ran detailed analysis on every outstanding bond in their portfolio. When they reached the Trump bond, the numbers were terrifying. With Trump serving as president, the political risk had exploded exponentially. The New York Attorney General was openly hostile. The courts had shown zero leniency. If Trump lost his appeal, Knight would be legally obligated to pay the state of New York over $500 million. The committee voted unanimously to terminate the bond. By 3 p.m. Tuesday afternoon, Knight filed official notice with the New York Supreme Court. They were withdrawing their guarantee effective immediately. Trump's legal team received notification at 3:47 p.m. They had until 5 p.m. Friday to secure a replacement bond or the automatic stay protecting his assets would lift. 73 hours, that's all the time they had to find someone willing to guarantee $557 million for the most controversial figure in American politics. The scramble was frantic and ultimately futile. Trump's lawyers contacted every major bonding agency in the Western Hemisphere. The answer was always the same. No underwriter wanted the exposure. The premium alone would have been astronomical, reportedly exceeding $50 million annually. Even then, nobody wanted to touch it. The political volatility, the legal entanglements, the reputational risk, all of it added up to one conclusion. Trump was unbondable. Thursday afternoon, his legal team filed an emergency motion with Judge Engoron requesting an extension. They argued the president was being unfairly targeted. They claimed the bond collapse resulted from market conditions beyond their control. They suggested the court was imposing an impossible standard. Judge Engoron denied the motion within 2 hours. His written reasoning was surgical in its precision. The defendant has claimed for years to possess personal wealth exceeding $10 billion. If that claim is accurate, he can post the required amount in cash. If he cannot post cash, then this court must act immediately to preserve the judgment creditor's ability to collect what is legally owed. The stay expires at 5 p.m. as scheduled. The order for execution of judgment is signed and will be served immediately thereafter. That order was signed Wednesday morning at 8:47 a.m. The sheriff's office received it by 9:15 a.m. The mechanism for seizing presidential assets is now in motion. So what exactly happens when the state of New York decides to take control of a sitting president's business empire? Let's start with 40 Wall Street because it represents the clearest example of how this process unfolds. The building is a 72-story skyscraper in the heart of Manhattan's financial district. Trump doesn't own the land underneath. He controls it through a 99-year ground lease that doesn't expire until 2076. Ground leases are valuable because you control the building, collect rent from every tenant, and profit from the property without owning the actual land. Appraisals have valued Trump's interest in 40 Wall Street anywhere from $200 million to $400 million, depending on market conditions and methodology. But here's the critical legal detail that makes seizure possible. Ground leases can be transferred, sold, or seized to satisfy court judgments. The New York City Sheriff's Office can petition the court to appoint a receiver. That receiver becomes the new controller of the property. All rent checks from law firms, financial services companies, and other commercial tenants currently paying. Trump's organization get redirected immediately. The receiver deposits that money into a court-controlled escrow account. Trump loses access to the cash flow instantly. The building continues operating normally. Tenants stay in place. But the revenue stream feeding the Trump organization stops completely. The receiver holds the money until the appeal process concludes. If Trump wins on appeal, the money gets returned. If he loses, the accumulated rent plus the eventual sale of the lease itself goes towards satisfying the $464 million judgment. Now let's talk about Trump Tower, the 58-story mixed-use building on Fifth Avenue that serves as both a residence and a symbol. The ownership structure is complicated. Residential condos occupy the upper floors and are individually owned by various people and entities. Those cannot be seized. But the commercial floors below the residences, the retail spaces, the office spaces, the public areas, those are owned directly by the Trump organization. Those can absolutely be seized. The same receiver process applies. Take control, collect rent, deposit into escrow, hold pending appeal. The symbolic impact of losing Trump Tower cannot be overstated. This isn't just a building. It's the physical manifestation of the Trump brand. It's where The Apprentice was filmed. It's where presidential campaign announcements happened. It's the Golden Tower that became synonymous with success and excess. Watching a court-appointed receiver change the locks and redirect revenue from this specific property would represent a humiliation beyond mere financial loss. Then we have Seven Springs, the sprawling estate in Westchester County spanning 213 acres of prime real estate. The property includes a 50,000-square-foot mansion, multiple guest houses, swimming pools, tennis courts, and extensive grounds. Appraisals have valued Seven Springs anywhere from $25 million to over $100 million, depending on methodology. The wide range exists because valuing estates of this size involves subjective decisions about development potential, comparable sales, and market conditions. But regardless of which appraisal figure you accept, Seven Springs represents substantial value that can be liquidated to satisfy the judgment. The seizure process for real estate differs slightly from commercial buildings. The court appoints a receiver who takes physical possession. The property gets professionally appraised by court-approved valuators. Then it goes to auction. Potential buyers submit bids. The highest bidder wins. The proceeds go directly toward the judgment. Trump loses the property entirely. These three assets alone, 40 Wall Street, Trump Tower's commercial floors, and Seven Springs, could potentially cover a significant portion of the $464 million judgment. But the Attorney General's office isn't stopping there. Sources close to the enforcement strategy indicate they're preparing to target additional properties across New York State. Golf courses, vineyard estates, any asset with Trump organization ownership that can be legally seized under the judgment. The goal isn't just financial recovery. The goal is maximum pressure, maximum symbolic impact, maximum demonstration that nobody, not even a sitting president, operates above the law. Now we need to address the constitutional crisis this creates because we have entered territory that the founders never explicitly contemplated. Can a state government enforce a civil judgment against a sitting president by seizing his personal assets? Does executive immunity protect presidential property from state law enforcement action? Can the presidency function effectively if the president is simultaneously battling to prevent his business empire from being dismantled? There are no clear answers because there's no precedent. Every previous president either divested from business interests before taking office or maintained such clean financial separation that conflicts never arose. Trump refused both paths. He claimed his businesses would be managed by his sons, but never created true legal separation. He continued profiting from his properties throughout his political career. Now the consequences of that decision are materializing in real time. The legal arguments on both sides are substantial. Trump's attorneys will argue that seizing a sitting president's assets interferes with his ability to perform constitutional duties. They'll claim executive immunity extends beyond criminal prosecution to include protection from civil enforcement actions that could distract or impair the president. They'll argue the founders intended the president to be shielded from harassment by hostile state governments. The New York Attorney General will counter that the judgment was issued lawfully after years of litigation. They'll argue the fraud was proven beyond dispute. They'll point out that Trump had multiple opportunities to post bond or negotiate settlement and refused every option. They'll argue that executive immunity cannot become a shield for massive financial fraud. They'll emphasize that allowing a president to escape lawful judgments would create incentive for future presidents to engage in misconduct, knowing they'd be protected during their term. The Supreme Court will ultimately decide these questions, but the timeline is uncertain. Emergency appeals can move quickly, but constitutional questions of this magnitude require careful deliberation. Meanwhile, the seizures can proceed unless a higher court issues a stay. The Appellate Division of New York Supreme Court could hear arguments within days. If they deny a stay, it moves to the New York Court of Appeals. If that fails, it reaches the United States Supreme Court. But here's the problem. The Supreme Court might choose not to intervene immediately. They might let the process play out at the state level while they consider the broader constitutional implications. That means seizures could begin before the ultimate legal resolution. That means Americans could watch law enforcement taking control of Trump Tower while constitutional scholars debate whether it's legal. The political implications are equally staggering. Trump's approval rating has dropped to 31% according to polling released yesterday. That's the lowest point of his presidency. Independent voters are abandoning him. Suburban women, a demographic that swung heavily toward him in the last election, are now turning against him at dramatic rates. Even within the Republican Party, fractures are appearing. Senators facing re-election in competitive states are quietly distancing themselves. They're calculating their own political survival. If images of sheriff's deputies changing locks on Trump properties dominate the news cycle, the political damage could become irreversible. Campaign donors are getting nervous. Fundraising has slowed noticeably. The infrastructure that powered his political rise is showing signs of serious stress. But let's game out what happens if Trump decides to fight back using the full power of the executive branch. Imagine he declares the seizure attempts constitute a threat to national security. He could argue that destabilizing the presidency creates a crisis justifying emergency action. He could order federal marshals to physically block state law enforcement from accessing his properties. That would create a direct confrontation between federal and state authorities. Federal marshals versus New York sheriff's deputies. Both groups armed. Both groups operating under what they believe are lawful orders. The potential for violent confrontation becomes real. Or consider this scenario. Trump issues an executive order attempting to nullify the court judgment entirely. He claims the ruling interferes with his constitutional duties and therefore cannot be enforced while he's in office. Legal experts universally agree such an order would be immediately challenged and almost certainly struck down. But the mere attempt triggers a constitutional crisis. It demonstrates a president willing to reject judicial authority. It raises fundamental questions about whether our system of checks and balances can function when the president refuses to recognize limits on his power. There's also the possibility of the 25th Amendment coming into play. Section 4 of the 25th Amendment allows the vice president and a majority of the cabinet to declare the president unable to discharge the duties of office. If the cabinet believes Trump's personal financial crisis is impairing his judgment so severely that he cannot make rational decisions in the national interest, they could invoke this provision. The process is straightforward but politically explosive. The vice president and cabinet members sign a letter to Congress stating the president is unable to perform his duties. Trump is immediately removed from power. The vice president becomes acting president. Trump can contest the declaration by sending his own letter to Congress claiming he is capable. Then Congress must vote. Both chambers need a 2/3 majority to keep him removed. If they don't reach that threshold, he returns to power. But the damage is done. The presidency is fractured. The executive branch is in chaos. Alternatively, imagine Trump announces he's issuing an executive order nationalizing enforcement in New York. He declares no state can seize federal property during his term. He orders Treasury to pay the judgment using emergency funds in exchange for dropping seizures. This would represent the most brazen expansion of executive power in history. It would trigger immediate impeachment proceedings. Democrats would have House votes. The Senate becomes the battleground. Would enough Republicans convict? If poll numbers collapse, if their political survival requires distancing from Trump, those votes might appear. Senate needs 67 votes. 51 Democrats need 16 Republicans. The founders worried about this scenario when drafting the Constitution. They feared a president whose personal financial interests could conflict with national interest. That's why they included the emoluments clause. That's why presidents traditionally use blind trusts. Trump refused. He claimed family management, but never truly divested. Now consequences arrive. The founders also worried about states having power to destroy a president. Federal authority generally supersedes state authority in national security matters. But they believed profoundly in rule of law. No person, regardless of position, operates above legal accountability. If a court issues lawful judgment, it must be enforced. The tension between these principles creates this crisis. This case will define executive immunity limits for the next 100 years. If courts rule for New York, presidents remain subject to state enforcement while serving in office. If they rule for Trump, sitting presidents gain complete immunity from civil consequences during their term. Either outcome dramatically reshapes American constitutional law. The question is whether our system can withstand this unprecedented pressure successfully. Thank you for watching Warfield Chronicles today. Hit that like button and subscribe to our channel. Share this video with anyone who needs to understand what's happening.